First and foremost, good morning, everybody. Hope you're doing well. My name is Eric Tonsel. I'm one of the shareholders in the POA department here at Roberts Markel Weimer Butler Haley. And today I'm going to be presenting on navigating neighbor-to-neighbor disputes in a digital world. Um, so I know this is a topic that comes up very regularly, especially the neighbor-to-neighbor dispute. So hopefully today's presentation will provide you some guidance and some understanding of what an association can and can't do and that kind of thing. So before we get started, the disclaimer as always, the information presented today is based on the laws that exist as of February 18, 2025. The information is presented for educational purposes and does not constitute legal advice. If you need legal advice relating to any of the topics discussed, please consult your attorney. Next slide, Kyle, please. So this is our agenda for today's webinar. And you know what, before I even go any further, so what I'm going to do is I ask that if you have questions, please enter them into the chat. At the end of the presentation, I will go through as many questions as I can within time constraint reasonability, I guess, and answer as many as I can. So please, if you have a question, please just enter in the chat. I'll get to it at the end of the session. So today's agenda, we're going to be talking about social media policies and what impact those may have with respect to neighbor disputes. I'm going to be talking about if and when the association should become involved in a neighbor-to-neighbor dispute and when to contact your attorney regarding a neighbor-to-neighbor dispute. And before we go forward, Kyle, I'm going to want to make this very clear that a lot of these neighbor-to-neighbor disputes are on a case-by-case basis. It is not a one-size-fits-all answer. And so, what may make sense for one association may not make sense for another association. A lot of it depends on the facts of the dispute, also the governing documents for the association and that kind of thing. So please keep that in mind. As I'm going to present some hypotheticals and some, kind of a guidance as to how to deal with those hypotheticals. But again, each situation can be different. So what may make sense for one may not make sense for another. All right, next slide, Kyle. All right, so first and foremost, here in 2025, as everybody knows, social media is become a preferred source of information and form of communication, whether it be Facebook, Instagram, Nextdoor, Snapchat, whatever. There's all kinds of social media platforms that are out there. And so as a result of that, a lot of owners like to be able to communicate with the associations and their neighbors through these social media platforms. And because of that, there's a lot more opportunity for homeowners to voice criticisms and escalate disputes either with neighbors or with the board or the association or whatever. And so, a lot of things that are said by owners, and unfortunately, a lot of these owners are a lot. You hear the term keyboard warriors quite a bit, where they're very aggressive or can be very aggressive on a social media platform versus if you were speaking to them face to face. So, a lot of times there's the question of, does the POA have an obligation to become involved in these types of disputes? And so we're going to get a lot more of that as we go forward. This is just the background of this presentation. Next slide, Kyle. And I see questions about, can people record this? We do record this session or this webinar. It will be available on our website for viewing later on. So don't worry about recording what you're watching. So if somebody's out there with their phone doing this, you don't have to do that. It's okay. We'll take care of that for you. So with the advent of social media and all that's and all that implies, if you're going to use social media from your association for your association, you got to have a plan. If you just fly by the seat of your pants, there's a very real possibility that it could result in potential liability to the association, depending upon what transpires. So because of that, we recommend that boards consider adopting social media policies to govern use of social media. To be clear, a social media policy does not apply to unofficial association pages or threads or whatever you want to call it. It will apply to if the association has an official Facebook page or their website with a chat room or something along those lines. Those are examples of what the social media policy will govern. It will not, if an owner creates their own unofficial Facebook page for the community, the social media policy is not going to cover those types of unofficial social media pages. Next slide, please, Kyle. So what is a social media policy? It's a policy that's adopted by the board, solely by the board. It does not require a vote of the owners. So because it is a dedicatory instrument, it must be recorded during the open session of a board meeting by the board of directors. Obviously, they can give proper notice of the meeting to the owners prior to holding the meeting to adopt a social media policy. The policy includes, by way of example, the terms of use. It identifies the purposes of the policy. It can address, community-related posts like lost pets, social activities, babysitters, contractors, all that kind of stuff. You're not going to allow anything obscene or unlawful to be posted on the association's social media platforms. There's going to be a prohibition against harassment and threatening comments. Refrain from posting copyrighted materials or images. No advertising or junk messaging. Again, these are just suggestions for what should be included in social media policy. So in the event that an owner or resident violates the terms and conditions, there are consequences that I'll get into here in a little bit that can be included in the social media policy as far as, I hate to use the word punishment, but ramifications as a result of not abiding by the terms and conditions of the policy. And also we recommend not including the policy prohibiting posting personal information about your neighbors, no complaints, no gripes, no images, that kind of thing. So those are the kinds of things that a social media policy will encompass as far as giving the association governance over owners and residents' use of the association's official social media platforms. Next slide, please, Cal. So what are some, proposed, as I use the word punishment. Again, I don't like that word, but what are some consequences? There you go. There's a good word. What are the consequences if an owner or resident violates the policy? One could be that whatever the post is can be deleted without notice to the person that posted it. For example, if you prohibit, the social media policy prohibits posting photos of like your neighbor's yard, and an owner does that because in their minds there's a deed restriction violation and they post a picture of an alleged violation next door. The policy will allow the association to delete that post without notice to the owner that posted it. And if you have continued or egregious violations, it allows the association to terminate that owner residence's access rights to the social media platform altogether. So if you have, for example, somebody that's threatening to beat up everybody on the platform, or just things that are just really outrageous, the policy will address those issues and can deny that owner access rights. And so who is going to administer this policy? That's a very important question. First of all, you need to have somebody that is going to be diligent and keep up with the social media platform. If you have an absentee administrator, that's not very good. People could be running rampant, could be Wild West on your platform, and there's nobody minding the store. When you're considering who's going to be the administrator, it could be a board member, it could be a committee member, or it could be your association manager. Now, keep in mind, if it's the manager, there is most likely going to be a cost factor involved. They're probably not going to do that out of the goodness of their heart. They're going to charge for that. So if you do consider using your manager as your administrator, keep in mind there may be a cost associated with that service. Next slide, please. So now let's get into neighbor-to-neighbor disputes. And again, the social media policy is very helpful in navigating these types of disputes in some circumstances. A lot of times, I'm sure a lot of the managers and board members on this call, you deal with neighbor-to-neighbor disputes that never make it to social media. They're just, people complaining, and they contact the manager or a board member and they talk about, Mr. Jones did this, Mrs. Smith did that. And so it never makes it to the social media platform. But in any event, and the purpose of today's presentation, obviously social media policy is good for complaints that are made on social media, but obviously we're going to have circumstances where the complaints are lodged just by a phone call or email to the association or manager. So common issues that involve neighbor disputes, maybe fireworks, barking dogs and pets, parking issues, boundary disputes. Maybe somebody puts a fence and the neighbor says, hey, you put that on my side of the property line, not your side. Noise disputes, maybe there's loud parties next door, or obstructing views, which that's when I really got into with one of my clients about a year or two ago, and that was very interesting. They got Wayne Deltrafino involved in that. That was, and for those in the Houston area, you know who that is most likely. So they can really get escalated and result in litigation, as that one did actually. By way of example, I think I've mentioned this before, but if not, if you haven't heard it, I had one situation where a neighbor would go in their second story, stand on the toilet in their guest bathroom, and step on their tippy toes and look out the top of the window to see over the fence so they could see something in their neighbor's backyard that they didn't like. And they insisted that the association get involved to address the alleged violation. Obviously, that is the quintessential neighbor to neighbor dispute. Oftentimes, the neighbors don't like each other. And they're going to be the Hatfields and McCoys, and they're going to complain about each other to the association and demand that the association get involved and spend their money, the association's money, to deal with the issue, when it is truly a neighbor-to-neighbor dispute. And again, I'll get into the complaining owner's recourse that does not involve the association. They can handle it on their own if need be. Next slide, please, Kyle. So again, increasing use of social media just makes it easier. You can broadcast it to a wider audience. And so that's why a lot of owners and residents use social media to really get their discontent across to a bigger audience. And so that's where the whole social media policy comes into play, because we don't want to perpetuate a breeding ground for just having people at each other's throats. So that is where the social media policy really comes into play. And again, as I mentioned earlier, there's official and unofficial association social media pages that can really perpetuate and escalate these disputes between neighbors, which can really, and quite frankly, let's be real. When you're on the associations, let's just say their official website or official Facebook page, you don't go there to read, it's not trash TV. You're not getting on there to see who's fighting with who and who's doing what. You're going to those platforms to obtain useful information as it relates to the association. For example, here in Houston, we have a lot of hurricanes. A lot of people go to the association's social media platforms to get updates about, is the pool going to be open? Is what happened on Elm Street? There's a tree down. What's going to happen there? So owners typically go to these platforms to obtain information that's beneficial and useful, not to read the latest he said, she said between Mr. Smith and Mr. Jones. So that's why it's really important to monitor your social media pages. Next slide, please, Kyle. So when to get involved? This is probably the majority of why most of you are on today's webinar. And again, as I said earlier, it is not a one-size-fits-all. Let me be very clear on that. So the board will need to ask itself, to the extent of the issue of this or the dispute, first of all, is there a violation of the restrictive covenants? That's a very important one to ask. It may be a situation where we don't have any jurisdiction over the dispute. By way of example, I had a situation fairly recently where two neighbors got in a fist fight in their front yard. And, it's, for those that may not know, the association is not a guarantor of safety or security for the residents in the community. That is beyond the scope and purview of the association's jurisdiction. We are not law enforcement, okay? Our role, our job, our jurisdiction is to enforce the governing documents that are applicable to the association and corporate governance of the association. We are not the law. And so in the case that I just mentioned, where there was a fist fight, that is a threat to personal harm and safety. That is, you don't call your HOA if there's a fire at your house. You call the fire department. Same thing goes where if there's somebody threatening you with a gun outside your house, or there's a fist fight in the front yard, you call the cops. So that's very important, again, because, situations, there's some neighbor to neighbor disputes that are just not an association issue. And when it says violate the restrictive covenants, for example, a lot of your declarations will have a nuisance annoyance provision that says that owners and residents are not permitted to engage in any activity that may become a nuisance or annoyance to the subdivision or to the community. Okay. And that last part is very important, to the subdivision or to the community. If this is the Hatfields and McCoy scenario that I mentioned earlier, or just two neighbors that don't get along and they're just at each other and trying to get the other one, in trouble, that is not a nuisance or annoyance to the community or to the subdivision. That's a nuisance and annoyance to each other. That is a neighbor to neighbor dispute, and they need to resolve it amongst themselves. In most cases, again, it's a case dependent situation on the facts and what your declaration or restrictive covenants say. But that's very important to keep in mind. And there is recourse for owners, and I will get into that on a later slide. So I'll just keep going forward from that for now. Is there a possible depreciation of property value? If so, that may be a situation where the association may need to get involved. Also, is it a disturbance to multiple neighbors? That's different. If you just have one neighbor complaining about the other, that's most likely, not in all circumstances, but most likely going to be a situation where the association does not get involved. But if you have everybody on the street complaining about this one house and the loud parties and the parking in the street and the trash that after the parties are over that are in everybody's yards, that is affecting more than one person, and that may be a situation where the association does get involved and enforce, in this, my hypothetical, the nuisance annoyance restrictive covenant. So again, case by case basis on what you're going to do there. And so social media threats should also be taken seriously and immediately turned over to law enforcement. Again, if somebody gets, are making threats of physical violence or whatever against another owner on the association's social media platform, that should be, relayed to the law enforcement. Again, we are not the cops. That is not our job. Next slide, please, Kyle. So again, when to get involved, check your restrictions. Do you have a duty to enforce? Is this a clear-cut violation of the restrictive covenants that requires deed restriction enforcement by the association, or is it discretionary enforcement? And so we've already kind of talked about those two types already. Again, possible violation of the covenants, that is a situation where the association most likely will get involved, but again, it depends. And failure to act may create liability for the association. Believe it or not, there's a situation where the association could be held in violation of the FHA, the Fair Housing Act, if it fails to act. And that involves, race, sex, national origin, all those elements of a FHA claim. And if so, an association fails to get involved, there is a possibility that the association could be held liable under the FHA. So again, that's certainly, I'm not going to get in the weeds on that. But, by way of example, I'm trying to remember, there was a situation several years ago now where a neighbor was displaying a Confederate flag, and their neighbors were African American, and they were displaying the flag, as a, to get at their neighbors. And so that was obviously, a race issue. And so that's where the FHA can get involved. And if the person that's being the victim in this hypothetical, raises an FHA complaint and the association fails to take action, that's where the association could potentially be held in violation of the FHA. So that's where the potential liability could be created for failing to act. So other considerations, is it the best use of community funds and time? Keep in mind, if the association gets involved, they're going to be spending association dollars to get involved in the enforcement, whether it be, filing a lawsuit or whatever. Whatever the case may be, you're going most likely to be incurring attorney's fees. So is this a situation with just one-on-one, let them handle it, duke it out amongst themselves? Or is this a situation where, this is, a situation where it does merit having the association get involved and spending association dollars to deal with the dispute. And then lastly, community support or disapproval. Maybe a situation where the most, if not 98, 99% of the community really doesn't care about what's going on, versus if there's widespread disapproval or widespread support for the association to get involved, that could certainly influence whether or not the association is going to get involved in these types of disputes. Next slide, Kyle. As I mentioned earlier, owners do have a right, do have recourse if the association does not get involved. And what is that recourse? Under most restrictions, owners, in addition to the association, have standing to enforce restrictive covenants against another owner. So here's some sample language here down at the bottom. I won't read it to you. You can read it yourself. But basically, that's something that you may want to look at in your covenants to see if you have that type of language. But basically what that means, again, let's go with the hypothetical I mentioned earlier about the guy in the bathroom on his tiptoes looking over the fence. That's something that I would not advise my client to get involved in. But if that whatever's in the backyard is in some way a violation of the restrictions, but it's only affecting this guy when he, again, tiptoes, second floor bathroom, that owner has a right to file suit against that owner for being in violation of the restrictive covenants. So that is, a lot of times that is the route that we take depending upon the circumstances and the facts as it relates to the dispute between the neighbors. One thing that is important is the owner standing to bring in action for violation of the restrictive covenants does not apply to collecting assessments, levying fines, or self-help. Those are enforcement mechanisms that are only available to the association. So if two owners are going at it and one owner finds out the neighbor is delinquent, the owner cannot file suit against the owner for being delinquent in the payment of assessments, cannot enforce the association's lien rights, etc. All right, next slide, please, Kyle. So when to get involved, allowing reporting through social media places the page and the association at risk. I do not encourage owners to basically out their neighbors on social media. If a neighbor has a complaint about an owner or a neighbor, whoever, those complaints should go through, proper channels, that being either a phone call to the manager, an email to the manager. If you're self-managed, an email or phone call to the board. What a letter or old school letter to the association advising of the issue. Disputes can escalate quickly, which affects the community as a whole, and so that's when as I mentioned earlier, if something an activity or action is being conducted or engaged in by a resident that's affecting a big number of residents in the community, that is something where the association should definitely consider getting involved. And then private message features are not alternatives for reporting violations. As I mentioned earlier, have owners, because obviously owners are going to have legitimate complaints. I don't think any one of us live in a community or work with a community where it's utopia and everybody gets along, there's no problems, and everybody's following the rules to the T. So there are circumstances where legitimate complaints come in, but those complaints should be directed through the proper channels and not through social media. Next slide, please, Kyle. So enforcing your social media policy, should you choose to adopt one, posts that violate the policy, then the terms of use should be removed, as I mentioned earlier. Also, the association should consider taking a screenshot of the post that violates the policy, just as proof, because a lot of times owners are do not appreciate being having their rights of access terminated. And then they'll allege that I didn't post that, I didn't do that, this, that, the other. So having that proof of the violation is very important to substantiate the association's decision to have that particular individual having their rights suspended. And also, having these screenshots is very important if you're going to have consider attorney involvement. I get that all the time, where I get photos, screenshots from texts or from Facebook or where Nextdoor of what's going on. It gives me, personally as the counsel for the association, a bigger, more in-depth picture of what's going on out there versus if I just get a, 3-sentence email saying, hey, Eric, we have issues here. I need you to send a letter. We need to get involved. Well, I need more than that because it may be a situation where, it's not a matter for the association to get involved in. Again, information is key. The more evidence, proof, examples you have will help not only the board, but if you're considering attorney involvement, having somebody like me review everything in its totality and being able to come up with a better plan of action going forward, whether it be involvement or not involvement. So it all depends. Next slide, please, Kyle. There's also, just so you know, there's alternatives to filing a lawsuit for neighbor-neighbor disputes. Neighbors could consider mediation, which is a form of alternative dispute resolution, or ADR. And mediation, by way of example, is beneficial because it saves time and money. You're not going through a lawsuit. You avoid litigation and high attorney's fees. Typically, it's a faster resolution if you guys can come to terms at a mediation. You have a third-party, independent, neutral facilitator being the mediator. So that's always good to have a third set of eyes, kind of review everything and make the determination based on the evidence that's been provided. And lastly, you can have confidentiality in the mediate. If there's a settlement in the settlement agreement, you can have that confidentiality provision that prohibits disclosure of the settlement without either court order or the party's permission. Next slide, please, Kyle. So when do you contact an attorney? A couple of things. And again, this is not an all-inclusive list. Let me be very clear on that. But if the parties refuse to cooperate, if the disputes involve a violation of your restrictive covenants, the association is unsure of its duty to enforce, meaning, we're not really sure if we have jurisdiction over this dispute between these neighbors. So that's something where you might want to get with your attorney and find out whether or not this is something that falls under our purview or it does not. Number 4 is dispute affects others in the community other than the parties at issue. We've already talked about that. Again, depending upon the level of impact on the community, it may be a situation where the association should get involved. Number 5, issues involving complex property law. I mentioned earlier in one of the previous slides about boundary disputes. Those are situations where there may be some pretty complex property law, whether it be for example, adverse possession. The fence has been there for a real long time, or that kind of thing. It just it may be a situation that is better served consulting with your legal counsel to find out what's going on here, what are we dealing with, should we get involved, should we not, that kind of thing. And then the last thing is the FHA issues, which I mentioned earlier about the Confederate flag hypothetical, although that was a real life situation, unfortunately. But these are just 6. There's plenty more. Basically, good rule of thumb: when in doubt, contact your legal counsel to see what options or enforcement options you may or may not have, and whether or not to get involved or not get involved. Next slide, please, Kyle. And so just so you know, for those that may not be aware, Section 5.006 of the Property Code is the attorney's fees provision that states that when an association enforces the enforcement of its deed restrictions, more specifically a violation of the deed restrictions, the association can seek to recover its attorney's fees involved in that lawsuit. Now, obviously, you need to prevail in the lawsuit, and the court has the discretion as to the amount of the attorney's fees that are going to be awarded, depending upon, you'll see in B there, those are the factors to consider reasonable attorney's fees. So again, if the association does make the decision to get involved in a neighbor-neighbor dispute and actually file a lawsuit against one or both of the owners in this hypothetical, then you can seek to recover your attorney's fees if you prevail. Now, the statute, if you see there in A, it says, in an action based on a breach of restrictive covenant pertaining to real property, the court shall allow to a prevailing party who asserted the action reasonable attorney's fees. So that's important because, and this doesn't only pertain to neighbor disputes. Let me be clear on that. Let's say an owner fails to mow their grass, and despite 209 letters or demand letters are still not they still haven't mowed the grass. You end up filing a lawsuit against the owner. The owner does not file any type of counterclaim or any type of anything seeking any affirmative relief against the association. The owner is simply defending the lawsuit. And in the lawsuit, the judge makes a determination that in favor of the owner, and the owner prevails in the lawsuit that was filed by the association. Again, pursuant to 5.06, the party that brings the action and prevails, and brings the action. In this hypothetical, the owner did not bring an action. The owner was simply defending the action that was brought by the association. So even if the owner prevails in that hypothetical, the owner is not entitled to seek the recovery of their attorney's fees. So that's an important part that a lot of people may or may not know, but it is very important. Now, again, to be clear, if they file a counterclaim, maybe alleging a DEC action, which is a declaratory judgment action, or something that does allow for them to seek the recovery of attorney's fees, then that changes the game. That flips the script. Okay. So it's only if we file a suit against an owner and they don't file anything, any kind of counterclaim in response, then in those circumstances, if they prevail, they're not entitled to recover their attorney's fees. But if we prevail, we are. All right. And last slide is the conclusion. For this presentation, associations should implement and lean on social media policies to manage disputes as much as possible. It's an effective policy can prevent full-blown neighbor-to-neighbor disputes, which nobody wants in their community. And lastly, strongly recommend that if you are considering adopting a social media policy, get with your legal counsel to draft the policy. And then also, as I mentioned earlier, if there's ever any questions about neighbor-to-neighbor disputes in the association's jurisdiction or when to get involved or not, again, that's something that you should probably consult your attorney on to make sure that you're not stepping into some gray area or quite frankly, sticking your nose somewhere where it doesn't belong. All right, that is the conclusion of this presentation. So I will get to the to the chat. I'm going to start from the top. Lots of questions, looks like. All right. Forgive me, there's a lot of administrative ones at the beginning. Okay, here's one from Bradley Burkeen. If you have a restriction on rental stating that it must be the entire home and you are sent a Facebook post with someone stating a room for rent, would the association then step in and send a violation letter, even if the room does not get rented, even if the post was not on the community page? Well, I mean, if it's a violation of your restrictions, then yes. I mean, assuming I have plenty of associations that have prohibitions that say, or restrictions that say that only the entire lot can be rented at one time. You cannot rent out rooms. And so if there's an active listing on Airbnb or wherever, renting out a room, that's clearly in violation of your restrictions. Yeah, that's certainly something that you could pursue as a violation of your restrictive covenants. Is a passive comment about slashing tires considered a direct threat? I kind of need more information on that, Clint. Clint is actually one of the managers I work with. I hope you're doing well, buddy. It depends. I mean, if there's actually a slash tire, then that's something that if the comment was made by one owner to another owner, that's a threat to somebody's personal property. Again, that is not our jurisdiction and purview. Okay. We're enforcing the deed restrictions and, corporate governance. We're not, guarantors of safety, security of personal safety or property. Okay. So that's something that if that owner feels threatened enough, that owner that received the threat should communicate that to local law enforcement. So my comment, this is from Cheryl, my comment pertaining to that last question is, wouldn't the action be dependent upon verification? My experience is that social media posts are notoriously gossipy and unreliable. I'd be very leery of anything stated on social media without additional substantiation. I would invite them to reach out to the management team with documentation first and go from there. It's great advice, Cheryl. This is Michael Shern. If an HOA board decides to establish a social media platform, should only owners and management company be allowed access? And 2, owners must use their normal legal name, not a screen name. The answer number 1, I would say, is yes. There's no reason for somebody living in a different subdivision to have access to your community's social media platform. As far as owners' use of using their normal legal name, not a screen name, I don't necessarily have an issue with an owner using a screen name. Because if they register to use the platform, then you're going to already have their official name, in your records. So I wouldn't necessarily require, and you can if you really want to, but I don't think it's that big a deal because you already have the registration information. This is from Tom. Are attempts to divide the community on a belief, for example, political or religious, considered neighbor-to-neighbor disputes since it affects larger groups of property owners? Should the majority group be allowed to influence the board to support their cause? Again, we are a nonprofit, or I assume 99.9% of you on this call or on this webinar are part of a nonprofit property owners association, whether it be a single family residential or a condo association. We do not promote or do anything with respect to political or religious activity. In fact, it's probably stated in your articles of incorporation or your certificate of formation, specifically that the corporation was not established for political or religious reasons. So if that is not something that the association should get involved in if it's political or religious. That's beyond the scope of why the association was created. This next question is from Rick. Can you speak to dog barking complaints from one neighbor only and when it would not be neighbor to neighbor? Yeah, if it's just one neighbor complaining about a dog barking, usually, Rick, that is something that I would advise my client is your quintessential neighbor to neighbor dispute, and that the owner who is complaining about the dog has the right to, as I mentioned earlier, to enforce if there's noise restriction or nuisance annoyance restriction. If they want to spend their own nickel in pursuing that owner for the dog, then that is certainly their right to do so. Another question from Tom. What guidelines do you recommend for individual board members regarding posting on either an official or non-official POA social media platform? It is possible for board members to speak as a property owner rather than a board member. I typically strongly advise against board members posting on unofficial social media platforms. You're right. A board member could post in an unofficial, and not in their capacity as a board member, but in their capacity as an owner on those platforms. But I've seen it happen too many times where a board member may be doing that. By that, I mean posting in their individual capacity as an owner rather than as a board member on an unofficial page. But that just leads to problems down the road. People don't make that distinction. They see that Tom Jones, hey, he's one of our board members, and he had a very strong opinion on this issue, and it's just not a good look. There's much more bad than good that can come from that. So my advice would be for board members, if you're going to post something on social media, only do it on official association social media platforms. And number 2 is make sure that you discuss it with your other board members before you post anything, because you may be a lone wolf. You maybe have a strong opinion about something that does not represent the collective opinion of the board, and you post that, and then that can create dissension. That can create a lot of problems. So again, if you're going to do that, make sure that you speak with your other board members. All right, this is from Eve. What is a DEC action that you mentioned when discussing eligibility to cover attorney's fees? A DEC action is a declaratory judgment action, Eve. And that is where you're asking the court to make a declaration of an issue, and that's I can't recall the statute number off the top of my head. My apologies, but that's a DEC action is again declaratory judgment action, and that is a cause of that's a suit that can be filed for the court to make a determination. And in a DEC action, the prevailing party can seek the recovery of their attorney's fees. Carol, if a neighborhood has a commercial business that is also part of the HOA, and the commercial business has several known violations that are in violation with federal laws, example, immigration, animal control, and septic issues, what is the proper channel to contact the federal agencies? Well, that is, that's something that, Google is your friend in that circumstance. So depending upon what city or county you're located in, Carol, I would Google as far as, type in, animal rights violations. And if you're in Harris County, and that will guide you to the proper agencies to communicate with to report a violation. Should it be the HOA, management company, or a resident? Well, if the HOA does not have any personal knowledge of the issue, it should be the person that's complaining about it. If the association does have personal knowledge and is aware, then typically it would be the management company, but not always. That's not a one size fits all. It would be better coming from, quite frankly, an individual owner. From Christine, should boards have a policy that address a board member commenting on a social media site? This kind of goes hand in hand with what I just said, Christine, as far as, boards should, present a united front when they're communicating on social media sites. Again, typically the official association and social media platform. A lot of times boards adopt what we call a code of conduct, which again is another policy which kind of governs, and typically when I draft these, it's for board members, officers, and committee members, and basically says what they should or shouldn't do. And one of the parameters in that code of conduct is communication on social media platforms. So it's definitely not a bad thing to have to prevent kind of a lone wolf situation that I described earlier. All right, Delana, regarding FHA, what is the best way to ensure association is limiting liability for not acting? Would sending a violation notice suffice? Yeah, but I mean, it's not just sending a violation notice and one and done, wash your hands, you're done. I mean, in the Confederate flag hypothetical, you really got to pursue it, not just send one, courtesy demand letter and be done with it. You really got to pursue it. If you don't, then there is a very real possibility that the victim could, file an FHA claim against the association. Can you give other examples of FHA violations? Off the top of my head, I really can't. It's really the discrimination one that really comes to mind, Beth. That's the one that I've seen a handful of times. So apologies, I don't have any ready to fire off right at this second. Penny, if owners are emailing, letting us know many owners are concerned about a group home, how should that be handled? They believe it is a group home with how many people are in and out of the home. Well, Penny, unfortunately, there are very strong federal and state protections for group homes. Group homes are homes for people with disabilities, and the definition of disability per state and federal law is very, very broad, very broad. It's very difficult to prevent a group home from operating in a subdivision. And so that's something that's a very pointed question. That's something that you should talk with your legal counsel about. But like I said, I've dealt with group homes in over 20 years I've been doing this. And, people say, well, it's a commercial use of the property or they're doing this. It doesn't matter. Again, because of the state and federal protections. Now, if one of the residents in the group home goes next door and is threatening, neighbor, that's different. Now you can address that particular individual, not the group home in and of itself. Or if the group home, they have a lot of trash or they're not mowing their grass or whatever, and a lot of trash and debris like in the front yard, it does not give them carte blanche to violate the restrictions entirely. It just, by virtue of having a true group home, it gives them the state and federal protections to continue to operate in the community. Last question from Christine. Should an unofficial community website, should an unofficial community website state that it is unofficial? This pertains to a Facebook account using the name of the community. Yes, I do that routinely, where we will send notice to the administrator of the unofficial page saying that they have to include some language, like on the splash page or whatever it is, stating that this is not an official page of ABC Association. Does continuing it display? Okay, this is for me. Does continuing display Trump signs and flags that seem to be targeted against adjacent neighbors of a different ethnicity count as a discrimination? The HOA has no sign policy. Again, Eve, that's a very specific question. I would defer to your association's legal counsel on that one. I will say this. I mean, you know, and I'm not getting political here, but Trump obviously is the president of our country. And so it's going to be, that would probably be a hard one to say that was, presented for discrimination purposes. I'm not saying it's impossible. I'm saying maybe difficult, but again, that's definitely one that you want to consult your legal counsel on. Last one from Tom. This is off topic, but related to the board speaking as one. In a property owner Q&A session held during a board meeting, should a board answer questions directly without reaching board consensus or respond later after reaching board consensus? I would, if you're not sure how the board feels about it, Tom, that's one where I probably say, thank you for your question. The board is more than happy to discuss it and, provide a response at a later date. I mean, again, you don't want to get in a situation where you have one person speaking for the group and the group feels completely differently about the topic. All right, guys, that is all the questions that we have. Again, thank you so much for joining this afternoon. I hope you guys have a great rest of your day. It's been a pleasure presenting to you, and I hope it was useful. All right, I hope you guys have a great day. Take care, y'all. Bye-bye.